the Waldwick Planning Board formal session called to order. This is a regularly scheduled meeting for which the date, time, and location is set forth in the annual notice of meetings adopted by the Waldwick Planning Board and the reorganization meeting of January 2024. In accordance with the Open Public Meeting Act, said annual notice has been filed with the Borough Clerk, a copy posted in the vestibule of the Waldwick Administration Building, and copies transmitted within 7 days after adoption to the official newspapers of the borough as designated by the governing body, to wit, the Bergen Record and the Ridgewood News. Secretary, please call the roll.
Ms. Benedetti?
Yes.
Mayor Giordano?
Here.
Mr. Schatz?
Here.
Mr. Raimondo? Mr. Cavigo? Mr. Kowalski?
Here.
Mr. Misselwick?
Here.
Mr. Orovitz?
Here.
Mr. Basilico?
Here.
Mr. Panfile?
Here.
Mr. Vervoort?
Here.
All rise for a moment of silent prayer and the Pledge of Allegiance, please. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Thank you. At this point in the meeting, we invite anyone that has business before the board that is not on the agenda to come up for any comments. Seeing none. Next item, we have the minutes from August 7. Each board member does have a copy. May I have a motion to accept as written? Joe and John. Thank you. All in favor?
Aye.
Good. Thank you. Motion carries. We don't need to call roll for that, no. Resolutions are next for H&B Waldwick LLC. Each member also has a copy. Motion to approve resolution as written. John and Stan. Thank you. All in favor?
Aye.
Secretary, please call the roll.
Ms. Benedetti?
Yes.
Mayor Giordano?
Yes.
Mr. Schatz?
Yes.
Mr. Kowalski?
Yes.
Mr. Misselwick?
Yes.
Mr. Orovitz?
Yes.
Mr. Basilico?
Abstain.
Mr. Panfile?
Yes.
Mr. Vervoort?
Yes.
Thank you. Next up, any applications? There are none tonight. Next is old business. Any old business that anyone would like to? Nope, seeing none. Next up is new business. Review and consideration of the preliminary area in need of redevelopment investigation of properties in Block 107, lots 1, 3, 5, 7, 8, 9, 10, 11, 13, and 17.
Madam Chair,
Yes,
being the mayor of the borough, and this is going to be coming to me eventually, I recuse myself from listening to this.
very good.
This
Thank
thing
you.
is going to be made at the advice of our attorney of the board and also the borough attorney.
Very good.
I'll be downstairs, call me on my phone, and I'll come up.
Sounds good. And are there any council members that need to maybe recuse themselves? No? Paul, you're not on council anymore?
Mark.
Yeah, Mark,
Okay.
but good. Okay,
All right.
so my mistake on that one. Paul Schatz, great. Mr. Greigel? Wherever's comfortable for you. You have a choice.
Thank you.
If
Good
your,
evening.
if your usual chair feels more comfortable.
It's been a while since I've been here for anything, so I'll take a microphone here if that's all right.
Sure.
Thank you. Should I be sworn in first?
Yes. you raise your right hand? Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name, spell your last, along with your position.
Yes, good evening. It's Paul Greigel, Grygiel, licensed professional planner, also the planner for this board and the Board of Adjustment, as well as the Borough of Waldwick.
Mr. Greigel, if you could, for the benefit of the public, and I notice there is some public, could you give us briefly the benefit of your qualifications?
Yes, I'm a licensed professional planner in New Jersey. I was so licensed in 1999. I'm also a member of the American Institute of Certified Planners. I'm currently a principal of Phillips, Price, Greigel, Laney, Hughes, Planning and Real Estate Consultants. We are based in Hoboken, but our practice takes us throughout the northern and central parts of the state generally, and sometimes beyond. I have been the consulting planner for Waldwick for, some time now, a number of years now, over a decade. Our firm has been here since before 2000. I also currently serve as a municipal planner for about a half dozen other municipalities in Bergen County as well as in Somerset County. Beyond that, I represent applicants before boards, and I regularly prepare redevelopment studies and plans similar to the matter being heard by the board this evening.
Thank you.
Thank you.
You're welcome. I can just take it away if you like. Okay, thank you. The board has been provided, as well as the public has been provided, with the area in need of redevelopment investigation dated July 2024. It was made available in accordance with applicable statutes by the borough and the board. I will be reviewing some of the highlights of this study this evening. It's a rather lengthy report, so I don't intend to read it all into the record, but we'll hit some of the main points and on the various requirements that need to be met, as well as go into detail on the properties that are in the study area and my findings.
For the record, the report will be appended to whatever resolution comes out of this.
It may be helpful is, I don't know if the board members all have copies, but I do have at least, not the entire report, but the map that's included. So if any board members need an extra one, I think I'll use one handout now. Just for the record, this is Figure 5, area need of redevelopment criteria, directly as is included within that study. And I think it's useful just because it's an aerial of the study area, as well as lists the potential criteria that are met on each of the properties. Thank you. Thank you.
I have it, thank you. It's page 30 in the report.
I believe this Figure 5 is appropriate, again, to show the location we're dealing with. Again, the board and others, I'm sure, are familiar with it, but for the record, thanks. Block 107 is located between Franklin Turnpike on the east. You have Harrison Avenue on the west, Frederick Street on the north, and West Prospect Street on the south. There are 10 tax lots in this area. It comprises just over 3 acres of land. Just to step back 1 second with regard to the board's duty this evening, you've been referred this study by the mayor and council. It's in accordance with the state local redevelopment and housing law that sets forth the statutory criteria for redevelopment designation, as well as potentially for either these property or others, redevelopment plans or other municipal powers. But this evening, the only question before you that you'll be considering is whether or not one or more of the parcels in this study area meets any of the applicable criteria. I'll get to those, what they are, in a little bit. And it's your duty under the state law to listen to the testimony, review the report, and then at the end of that, have a public hearing to hear from the public, and then make a recommendation one way or the other back to the governing body with regard to your findings. And again, we can get to it at the end, but it could be that If you agree with me that the entire area is qualified, you can report that, or you can say certain lots, none of the lots, or make other recommendations as well. So that will be the end result of this evening's hearing. So I'll go roughly in order of the report just to make it easier if anyone's following along. Again, not going through everything in great detail, but just briefly, we outline in there what steps were taken with regard to the investigation, the information that was reviewed. So once we were authorized to prepare this study, we looked through the master plans and zoning of the municipality, tax maps, property ownership records, and other documents similar to that, as well as made requests of borough departments for information from the past 5 years with regard to everything from fire code and building code issues to police records and various other items, which when we receive them, we include them in the appendices of the report. And also visited the study area on multiple occasions. And in addition to that, what I do cite in our report is our firm and my own longstanding history in Waldwick as planner. So the study area is very familiar to me, not just from this most recent work, but over the past, again, let's call it roughly 20 years that we've been working around here. So just turning to the next, from the first section of the report to Chapter 2, the study area locational context, it lists all the blocks and lots that are included for the record, as well as property owners and addresses and the area of the properties as listed on tax records. There are maps showing this information. The report goes into detail on existing zoning and master plan designations for the area. Just to put on the record, because this may come up later, it's the C1 Village Commercial District. That includes the study area. It primarily is intended for various retail and other commercial uses. They are, again, all listed in detail in the report. Just note with regard to the master plan that this will be talked about a little bit later in the report, that for a few years now, Waldwick has made a priority of trying to improve its business district as well as the area around the train station. So there are some specific recommendations mentioned in there. So this is not a study coming out of nowhere, but it actually builds upon some master plan efforts that have been undertaken previously. And as the board and public may recall, also a similar effort to this that was undertaken about a year or two ago, I forget the exact date, for areas to the west of Harrison Avenue. I'll turn to you next. I don't have the page number of the report in front of me, but it's Chapter 4, so I apologize for the exact number, but this lists the statutory criteria under state law that are being considered here.
Page 11.
Thank you. Yes, I have a truncated version, so I don't have
No problem.
the page number. So page 11, Chapter 4. As noted, the state local redevelopment and housing law has 8 different criteria that are listed, and if any one of these or more are found on a property or an area, you can make a recommendation it qualifies as in need of redevelopment. 3 of these are relevant in this study. They're listed as letters A, D, and H. So I'll talk about those in the context of the various properties. Also discussed here is a concept in redevelopment planning known as Section 3, where essentially if a parcel doesn't meet any of these criteria but is necessary for the overall redevelopment of the area, the law allows you to recommend including it in that overall area. So this is commonly a case when you have a number of properties or a large property that surrounds a smaller one, and it's kind of the hole in the donut or the missing tooth, that type of thing, to try to fill in a larger area. So that would be dealt with as well. And I'll just say at the outset, there are 10 lots included in the study area. 6 of them meet one or more of the criteria. Again, they're all listed in there. I'll go into detail. They comprise over 2/3 of the land area of the overall study area. So I'll just continue into Chapter 5 in order, just to try to put briefly on the record some information on each of the properties. Again, there's 10 of them. I don't want to take too much of your time in the public's time with regard to details, but just hit some of the high points and findings. And if you're following along the map, I'm going to go through the lot and block numbers. So we're starting at the top left corner, Lot 1 in Block 107. That's 49 Harrison. This is a property at the corner of Harrison and Frederick. It has a 2.5-story single-family dwelling. I did note that the C1 zone does not permit single-family residential. It only allows mixed use, so commercial and residential together on properties. And this property is generally in fair to poor condition, both internally and externally. We did actually do an internal investigation of the dwelling to look at conditions inside the house as well as on the property. They are listed in here, but essentially there were a number of things that were concerning to me with regard to the condition of some of the internal fixtures, with regard to, the attic, the attic and cellar both having, issues with structural conditions and just the overall condition of the interior of the property. Not to mention the exterior had some issues as well. Because of the conditions listed in the report, I do believe that 3 criteria are met here, A and D. A is with regard to essentially that a building is substandard, unsafe, unsanitary, or dilapidated, or has any of those characteristics to make it unwholesome living or working conditions. And in this case, due to both interior and exterior concerns with regard to the structure and the property, the walls, the mold, dirty conditions generally, but also some of the building systems and the interior fixtures, I do believe that it would be it's considered an obsolete dwelling that has some conditions that certainly are detrimental to the safety, health, and morals of the community. Likewise, criterion D, deals more with the general property, areas with buildings or improvements that have dilapidation, obsolescence. Again, they're all listed in here, but a variety of factors, including things such as lack of light ventilation, sanitary facilities, excessive land coverage. It's really a catch-all for when you see a property that has some glaring deficiencies or potential problems that could be detrimental to the health, safety, and welfare. Again, they're all listed in detail. So I do believe those 2 are met. In addition, there's one more broad criterion, which I cite here, and on a number of other properties as well, so I won't repeat it, but it's criteria H, dealing with smart growth principles. The law was changed a few years ago to allow for parcels that, an area that would be consistent with smart growth planning principles adopted to a law or regulation. In this case, New Jersey does have various planning statutes and plans that promote smart growth, which is basically developing around train stations in downtown areas, places where you have infrastructure and roads and utilities in place already. Here, we're dealing with a property that's 1 block from the passenger rail station for Waldwick. It essentially would allow for, its redevelopment would allow for more appropriate type of development to take place in the area that is the downtown of the municipality and near a train station, near major transportation routes. The next parcel is Lot 3, 47 Harrison Avenue. It's just to the south. This is another residential structure. You have a number of residential structures along Harrison. In this case, I can cut to the chase that I don't believe it meets any of the individual criteria. There are some conditions with regard to its, the fact that it is a non-conforming use in the zone as a residential use, and there's some minor maintenance type issues, but in general, the property is in good condition, so it does not individually meet any of the criteria. But it will be one that I do recommend including through that Section 3 because it's, as we'll see, is surrounded by other properties that do meet criteria. Turning to Lot 5, continuing south down Harrison, we have the same issue with a single-family dwelling that's not a permitted use, but it's generally in good shape, it's well-maintained, nothing jumped out as being deficient and rising to the level of it being designated under any criteria. So I do not believe that you have any criteria met on that property as well. Moving again through the report and on to the next property further down the street. We're at Lot 7 now. That's 43 Harrison Avenue, roughly in the middle of the block, if you're following along on the map. This is a 2-story single-family dwelling with a 3-car detached garage in the rear. This property has a number of issues that are evident by looking at it. We do have photographs showing these conditions. One of the most glaring ones is a tree growing out of the foundation of the dwelling. Literally, there's a photo of that. The entire rear yard area is essentially paved. You do have a garage that seems more appropriate for commercial use, which I guess makes sense. It's a commercial zone, but it's a single-family dwelling. There are some other issues with regard to just some of the external improvements on the property, both within the yard, the building itself in terms of its siding and other portions of the foundation being covered in moss or mold. Again, just one of these things, when you look at it, you do see a number of characteristics that show either neglect or other problems that potentially could lead to public health, safety, and general welfare concerns. In addition, in the front of the property, there's when we were there in June at a site inspection, there's a large area of ponding in the street adjacent to the front property line, even though it hadn't rained for a few days. So there appears to be issues with drainage on the property, or at least on the street directly adjacent to it. So for those reasons and the others cited in the report, I do believe this property meets criterion D due to the condition of the dwelling and the garage, fencing, and the overall property that do talk to its essentially dilapidated, obsolete condition, and some potential health and safety issues with regard to the condition of the structure, as well as the potential issues with drainage and other issues from the overall overdevelopment of the property in terms of coverage. Criterion H is met, in my opinion, as well. That's the smart growth one. Next is Lot 8, going down to 41 Harrison Avenue. This property is also residential and has a 4-car detached garage in the rear. So we have another large garage structure on this property. The dwelling appears generally in good condition, but the garage itself is in pretty poor condition, a number of broken windows, the padlocked doors, there's patching with untreated wood and other materials on the garage doors. And there's actually a satellite dish on the roof of the garage, which is an interesting touch if it's not supposed to be used for habitation. So overall, the rear yard also has a number of, just the condition has a look of being a bit less than well maintained with some of the furniture that's out in the yard and other goods and materials on the property. Couch, dining chairs, that type of thing in the rear yard. Piles of cinder blocks, unsecured bicycles, it's all listed in here. But just a variety of items, even though the property is being inhabited, it appears to have a number of things that either don't relate to that or for some reason are there that just don't make sense on a typical residential property. So for those reasons, I do believe criteria D is met for this property as well, given the condition of the garage structure, the excessive pavement on the overall property, and again, under various other reasons listed in the report. Going down now to the last couple of lots along Harrison, they're dealt with together because they're in common ownership. They're lots 9 and 10. They were formerly developed, but in 2015, the improvements on the property were demolished. So for 9 years now, it's been unimproved. You can picture it being used as a parking and storage area along the corner of West Prospect and Harrison. Even though it's being used for that purpose, it's not really designed as a parking lot per se. It does not have any real formal striping or other features that you would have in an actual parking area. There's some asphalt that's severely damaged. It's both gravel and lawn area that kind of commingle. Other than some chain link fencing, there's really no separation from the sidewalk and the street in some areas, so you have a concern about the ability for cars either being parked down there, driving on or off the property in places where they shouldn't be. But just more generally, the fact that it's being used for surface parking in a downtown area, a block from a train station, that's been sitting in this condition for some time. Now, this gets into a detailed theory, if you will, in the report, which I can go into a little bit because I talk about this on this property on Rite Aid. The fact that in an area where you have smart growth being promoted, good planning being promoted to take advantage of a train station to enhance the downtown, surface parking, especially when not in good condition, is not an appropriate use of land that you would want to promote. That there is case law dealing with this issue, talking about parking areas being actually qualifying under criterion D of the statute because of the fact that it's really just contrary to what you're trying to do to improve the streetscape, to try to promote vibrancy and activity. It's more appropriate when we're talking about the Rite Aid lot, which we'll get to in a second. But if you picture that area, instead of having an expanse of asphalt and cars parked haphazardly and you name it, no drainage facilities, that type of thing, instead having a well-planned mix of uses or use that is actually designed in accordance with your zoning and your master plan for the borough. So in this case, lots 9 and 10 are serving sort of an interim purpose as parking, even though, again, this would be better utilized probably for permitted use, one that could take advantage of having a train station in walking distance, one that would be better maintained. Again, there's some maintenance issues on this property as well. I believe has negative aesthetic impacts on the surrounding area, and certainly does not help the streetscape to have 130 feet of frontage on West Prospect, 100 feet on Harrison that are just wide open for parking of cars, no buildings, no improvements, minimal landscaping fronting the street. So I think criteria D is met in this case, as well as criteria H for the smart growth. Next, we're turning the corner onto West Prospect to Lot 11. So this is a mixed-use building at 13 West Prospect. Now, again, jump to the conclusion here that I don't believe any criteria are met. This is actually the type of building you'd like to see potentially on the adjacent properties with ground floor commercial, upper floor residential, generally well maintained. There were some minor issues here and there, but nothing that rises to the level of saying it qualifies under any of the criteria. The issue is, though, it's surrounded, again, by other properties that do meet one or more criteria, so I do believe it could be included under that Section 3. Okay, second to last here, but the largest property by far is Lot 13. This is what's currently the Rite Aid property. I believe it was Genovese at some point before that.
Yes, Genovese.
I actually grew up not too far from here, so I remember that as well. And probably before that, maybe you can help me. Was that a grocery store there before that? Or?
Yes.
It looks like it would have been,
It
right?
was.
So we're going back 50, not to date anyone, but we're going back a number of decades here. This is a property that was developed for,
Yeah, it used to be a Pathmark, I believe it was.
there you go. So
It was
that's
still a Pathmark in the 80s,
Yes.
in
So that
the
was,
late 80s.
we mentioned that in here, that it appears that I couldn't find historical records. I didn't dig too deep on that, but just by looking at it, the way it's laid out, it appeared to be a grocery store. So it was a Pathmark, it became Genovese, it's Rite Aid. Essentially, you're dealing with a lot that is at a key location within the borough at what we call the 100% corner, typically in planning circles. It's kind of jargon for at your main intersection. Franklin Turnpike, Prospect Street. That's where you normally would like to have, impressive buildings. You do have a small park area there, but it's, surrounded by asphalt and parking. You have about a 20,000 square foot building with way more parking than is necessary for it. And that's evident, again, from my visits over the years. Just going out there tonight, you see a lot of cars parked down on the end toward closer to the train station. Yes, we have it. Well, that's the trend we're trying to, you shorten parking in some areas, in other places you have too much. Here you have a lot that, unfortunately, it doesn't have any drainage facilities. In terms of modern lighting, there's one light pole out in the entire lot. It's got two heads off it, that's it, so that doesn't meet modern standards. Certainly wouldn't meet current site plan or zoning standards. The lots striping, to the extent you can see it, is somewhat haphazard. You have some aisle widths that are deficient in terms of width. I did go into some calculations that if we used a more appropriate parking standard for the building that exists there, you'd probably need about 80 parking spaces. That's based on one space for every 250 square feet. There's 131 by my count, so about 50 additional spaces over what I think even there's a conservative standard for parking, 1 per 250. You probably can get away with even a lower number, but let's just call it, again, 50 or so spaces over what you need. In addition, unfortunately, it is documented by the police reports that parking lot is somewhat of a magnet for criminal activity. Some of it minor, but other cases where it's cars that are parked there, people sleeping in vehicles, suspicious activity being reported. A variety of things. I mean, we have a whole page plus worth of the summary of police reports. Some of these do relate to the Rite Aid use, in fairness, lost wallets, fraudulent activity, shoplifting, et cetera, in there as well. But there are actually a number of reports in here dealing with the parking area itself. Likewise, the building department has a laundry list of issues with regard to potential violations with regard to certain issues within the building itself, as well as the exterior of the property and its maintenance, snow shoveling or snow plowing, sometimes not happening in time, things such as that. On top of that, you also have the property as frontage on Frederick Street where there are some dumpsters. So that was where the loading area was for Pathmark and for the other stores. But it's not up to current standards. These are dumpsters just sitting out there in the asphalt paved area. There's no screening. Trucks that want to do any deliveries there need to utilize the street to K-turn. There's not nearly enough space to provide for current loading standards with regard to a commercial use. There's a lot more information here, but those are some of the main points with regard to this property. And really the last one comes back to the argument I talked about before for the neighboring property, or a couple lots away where you have the parking lot, that this is a main location within the borough. It's in a smart growth, transit-oriented area, and you're instead devoting over an acre of land to parking area, to pavement that's not even being utilized necessarily by the businesses that's on the property. Yes, it might be helpful, I'm sure, for other businesses, certainly, maybe for commuters, maybe for people that need to park a car full, that's great, but unfortunately, from a planning point of view, this is a prime property in a prime location that is contrary to what Waldwick's tried to do with its downtown and its station area. It's contrary to good planning principles, and I do believe for those reasons and a variety of other reasons listed here, this property does meet criterion D of the local redevelopment and housing law. It's detrimental to the health, safety, and general welfare due to the fact that, again, it's an obsolete, outdated solution for a downtown area such as this with an obsolete, outdated building on the property. It also, again, meets that smart growth criterion H, given its location in the downtown at a main intersection close to the train station. And just lastly, there's one other parcel at the corner, almost across the street from where we are tonight, Lot 17, 62 Franklin Turnpike. This is the mixed-use building with a deli, a hair cutter, some upstairs apartments. None of the criteria are met. It was a close call on this one. You do have, some conditions with regard to outdoor storage and trash, that type of thing, and its overall condition, but nothing jumped out to say this is a property that, in and of itself qualifies, but it does qualify, in my opinion, to be included under that Section 3 because it's, again, surrounded by other properties that meet criteria. It's, part of a larger area that would benefit from a redevelopment area designation. Okay, with that, I gave you a lot of information over the 10 properties. I can summarize the report now and then go back to answer any questions on specifics, to go into detail if you want. I'm sure members of the public might have comments or questions as well when we get to that. I'd be happy to answer them. But just the overall evaluation, that's what this map, figure 5 shows. Just to recap, we have 10 properties. 6 of them meet one or more of the criteria, in my opinion. The other 4 that do not are, again, bounded by other properties that do meet the criteria for redevelopment. So I do believe that the area would qualify overall, either through the designations of the A, D, or H that are listed there, or for those that don't have any individual designations, by the Section 3 inclusion in the overall redevelopment area. So that's the summary and conclusion of my findings. I'd be glad to answer any questions from the board at this time or go into more detail. Thank you.
Folks?
Paul, could you go into exactly what it means to have an area that's so designated in terms of what can and can't happen?
Yes. So the state law was enacted, many years ago to deal with, traditionally, just going through a little history here, it was more in urban areas, and it was, blight in the sense of you have, vacant, burned out buildings, that type of thing. It's evolved a lot over the years. The law has changed to change the wording, in fact, to get away from so-called blight, but to instead give municipalities a tool to say, okay, if you have an area that for whatever reason has fallen out of favor with the market, that has been abandoned, in some cases, met its fate through natural disaster or fire, that type of thing. Through any one of these criteria, it allows a municipality or borough such as this to designate it. That's just one step. What that means is then if the designation is essentially enacted upon by the governing body, the mayor and council in this case, a redevelopment plan can be undertaken and adopted. That would set new zoning for an area. That could change the particular uses that are permitted. In some cases, you allow the existing uses to stay. It's overlay zoning that allows additional uses. That's one of the tools. And another one is with regard to tax abatements or payments in lieu of taxes. So it's the ability for long-term abatements under the statute that allows for property owners to take advantage of that. In some cases, and in this one where it's a condemnation redevelopment area, the municipality does have the ability to condemn property, to use eminent domain. Of course, there's a whole procedure for that, that involves, fair market value. It's just not just they come and say, we're taking your land, and there's nothing beyond that. But that is one. A municipality can go in either direction with condemnation or non-condemnation.
Paul? In a condemnation, where condemnation is permitted, the municipality does not have to condemn all the properties.
Doesn't have to condemn any properties. It doesn't. It can or not. You can all, none, some. It's just one of the tools that's in there.
It's not necessarily a bulk solution.
Right. And that's why it's a rather drastic, tool. Certainly, it's acknowledged. That's why there's notice given to property owners. There's notice given in the newspaper twice in a row. 2 weeks in a row. That's literally the way the statute's written nowadays. But again, it's a whole series of procedures that would need to be followed if and when it gets to that point. And then for that matter, there are also procedures with regard to relocation of existing tenants or businesses. That's, again, there's a lot of detail that needs to be addressed with regard to before anything can happen where people are, certainly they're not being forcibly moved out of a property. It's a long procedure that involves potentially condemning property and then dealing with whatever is on that property.
As a practical matter, if a property is worrisome for some reason, there's still an opportunity for the property owner to negotiate and discuss the ultimate outcome of that property with the borough, is there not?
Yes. Yeah.
It's
Again,
not precluded.
no, this is, again, it's a long process here, and this is just the first step. This board, again, is only focused on, this evening at least, the main priority is looking at whether criteria are met or not. But that then allows you to make a recommendation, which then the mayor and council have to take seriously and say, okay, do we agree with you or not? And then they take the next step as far as whether or not that is designated, with or without condemnation powers. And beyond that, then the other steps, again, don't even need to, that's the other thing is, for example, the other redevelopment area, there's no big plan written, there's no plan whatsoever currently for that area. Again, Waldwick is moving slowly, methodically, there's no plan in place, that's behind the scenes trying to, take over this whole area.
And again, just so that we make sure the record is clear, the first redevelopment area was without condemnation powers, was it not?
I don't have it in front of me, that's my recollection.
That's
yes.
my recollection. However, again, to be very, very transparent, this one seeks condemnation powers.
Yes, by law, it needs to be stated right in the resolution authorizing it. Looking at the introduction of the report, says that right there. The state law was adjusted a few years back to you have to make it clear you're choosing one path or the other. Again, that said, the municipality can always move off the path if it determines, does not want to go in that direction. It's just you can't later on, if you do the non-condemnation like across the street, can't come back later and try to take property without going through the whole process again.
It simply gives the borough an option.
Yes.
Thank you.
And that happens here, not at borough, at council, correct?
So the designation would be here.
Yeah.
The initial designation. Well, the recommendation, you're just only, again, as planning board, you're statutory making a recommendation. There would then need to be essentially a resolution adopted after that by the mayor and council to say, based upon the planning board's recommendation, we designate this area. So there's multiple steps. There's a whole
Or they can
set of steps in
decline.
the process. They can say, we agree, we disagree. 1 property, 8 properties, 10 properties, no properties, right?
This is one of those things where it's a multi-step process and you can stop at any one of the steps.
Yes. And that's why I mentioned, even if there's a designation, there's no guarantee, there's no requirement to go forward to say, okay, now we're going to adopt a plan or enter into redevelopment agreements or do tax abatements or anything. Those are possibilities, but nothing happens without the first steps being taken. But nothing guarantees, you don't have to move down the road and guarantee that either.
Mm-hmm.
Any board members have questions, comments?
Questions now?
Questions right now, actually. No? I'll ask the public if they have
Okay.
questions.
Ladies and gentlemen of the public, this matter is about to be opened up for your questions, not your comments. Anyone who wishes to
Thank you, Paul.
speak has to come to the microphone, be sworn, because almost all questions involve giving information. And identify yourself and where you live. Saying that, Madam Chair?
Anyone from the public have comments at this point?
No, not
Questions?
questions.
Questions, pardon me.
Chairman Board, my name is Ken Poro. I'm an attorney with Chase and Lamparello and a neighbor of yours in Wyckoff. I represent Mr. and Mrs. Paschelis at 45 Harrison Avenue. That's block 107, lot 5, 45 Harrison. And if I could ask Mr. Greigel a couple of questions.
Certainly, Mr. Porro.
Great, thank you. Mr. Greigel, thank you for your candor. As to Lot 5 in your report, which is page 15 and 16, you had said that the property is in good condition and is fairly well maintained. Is that correct?
Yes.
And in fact, you concluded that there was no criteria in the redevelopment statute that would mandate that the municipality could take that property but for this redevelopment.
Well, just to be clear, there's no criteria that I believe were met for the designation of itself.
Correct. So, but for this redevelopment plan, Waldwood wouldn't have a basis on condemnation. They wouldn't have a public purpose to take this single-family home.
Not in and of itself, no, that's correct. If it was isolated, there's nothing in the criteria that's met that would allow for that.
And in all candor, ladies and gentlemen of the board, the power of condemnation is what gives my client pause. And I would say, just think of yourselves, if you
Mr.
own
Porro?
this property. I know I'm going a little off this thing, if you give me a little leeway, because I'll be quick then.
Okay.
The board does have the power to recommend that condemnation not be utilized. So as far as you had said, Mr. Greigel, there are other concepts such as an overlay zoning, is that correct?
Yes, well, I mentioned that in the context of a redevelopment plan, but that certainly is a zoning concept that could be utilized outside of the redevelopment framework.
And as far as when was discussed here by way of the negotiations, in fact, the negotiations are not made by the borough. Isn't it fact that the designated developer is the person who is negotiating the taking of the property?
It depends on what redevelopment agreement's entered into. You need a designation first, then a plan, and then a borough or municipality would enter into a redevelopment agreement that allows a developer to enter negotiations.
Are you aware, as far as the Pascalis property, that a developer did approach my client and they were not able to amicably come up with a purchase of my client's property? Are you aware of that?
The only reason I'm aware, just to be in full candor here, before the meeting, you actually mentioned that to me. Prior to that, I was not aware of that fact.
Fair enough.
Mr. Porro, for the record, what developer?
I'll provide that to you. I'll provide the name of it. My client is in Greece right now. God bless them, and their husband and wife. As far as, and I'm wrapping up, you had said in your presentation, the power of condemnation, your words, is a drastic measure. Is that the term that you had used?
I'd have to look back and say, but I do acknowledge that it's something, for the reason you are here, it is something not taken lightly, but it sometimes is necessary.
And as far, again, in my clients, and I believe in your report, again, thank you for your candor, there is no imminent danger associated with my client's property.
There's nothing that, based on our investigation from police records, property maintenance records, site visits, that jumped out as being a imminent health, safety, welfare issue.
My last point for the record, counsel, is that I had gone to the website, thank you, and got the report. I did not see, as required by the law, that notice was given to the adjacent boroughs. That would be Wyckoff, Hohokus, Saddlebrook, Allendale, Midland Park, and Ridgewood. I could be wrong, I didn't see it on the website, but respectfully, if that notice is improper, the hearing be. So I would ask that you carry this to make sure that your notice is proper, because if your notice is not proper, you will not comply with the statutory requirements. Thank you very much, I appreciate your time.
Thank you. Anyone else have questions at this time? Seeing none.
I just have one question for Paul.
Yes.
Are any of these properties, lots 1 through 10, commonly owned by more than one individual? Or are they separately owned by different individuals?
There's actually a listing which I can refer to on, it's page 2 and what I'm referring to. So there are a few that are common,
Okay,
but it's not an overall, one owner at this time at least, according to tax records.
yeah,
So you have, the Pascalis property is individually owned, next there's the Doyle, Syracuse on the other way. There are 2, lots 7 and 8 owned by the same individual.
okay.
And then lots 9 and 10, that parking area one I talked about. Those are both
Thank you.
Waldeck Development Corp.
Thank you.
But the other ones are all different owners, yes.
Okay, thank you.
Madam Chair, could we adjourn for about 5 minutes?
Sure.
Thank you.
We are adjourned for 5 minutes.